very favorable to members of the public to be able to have access to their records. So public records law isn't just an annoyance or distraction to government officials. Rather, it's essential again to our democratic ideals. Now, there's also going to be a lot of practical reasons why the Ohio General Assembly, which is our state legislature, has mandated that this 3-hour training be taken by elected officials or their designees. First, if you fail to comply with the public records obligation, it can lead to liability, both civil and potentially criminal, and other litigation. So this means not only just a lot of time wasted and headaches, but possibly a lot of money too. But second, understanding public records law is going to make it easier for public offices to respond to requests. A well-informed public office is able to handle its public records requests with more satisfaction to the requester, resulting in less burden on the office. Now, most of today's training today is going to be focused on the Ohio Public Records Act. And we're going to look at a lot of different things. We're going to look at who's subject to the act. What is a public record? It's not going to be too surprising to a lot of you to know that a lot of these are going to have very specific definitions that are applied. We're also going to talk about what are the obligations of the requester and what does it mean for a public records request to be proper and enforceable. We'll look at the obligations of the public office when responding to a request and any exceptions or exemptions that might apply that would otherwise allow an office to redact or even withhold records in whole. We'll then look at the consequences of not properly responding to a public records request, including the two main types of litigation and legal remedies that are available. And then finally, we're going to share some best practices on managing a public office's records, including records retention and destruction. So with that, let's go ahead and dive in. So first, what is a public record? Well, the Public Records Act defines a public record as every record that is kept by a public office. So let's go ahead and start with this last part of the definition first, which is what is a public office? Now, the statute defines public office as any state agency, public institution, political subdivision, or other organized body, office, agency, institution, or entity established by the laws of this state for the exercise of any function of government. Well, that's a pretty wide and broad definition. So what you really need to take away from this is anything that you can think of that would fall under the government is what's going to be subject to the Public Records Act. This means stuff as low as a local school board all the way up to the governor's office. With that being said, the Public Records Act can also apply to private parties and private entities if one of two scenarios is present. Now, the first scenario is when a private entity or person is found to be responsible for public records. Now, it's very common in today's age and even in the past that public offices would delegate their duties to private entities. For example, a public office might hire an outside search firm to help them fill an open position in their office. Or what we see all the time here at the Attorney General's office is that we might hire outside legal counsel to represent a public office when for some reason our own office's attorneys cannot. Well, in these types of situations where a public office contracts with a private entity to perform government work, then the records related to that work might be subject to the Public Records Act if three conditions are met. First, the private entity prepared the records to perform responsibilities normally belonging to the public office. Second, the public office can monitor the private entity's performance. And third, the public office may access the records itself. Now, under these circumstances, the public office is going to be subject to any requests that it receives for public records under its jurisdiction. including any records that are solely in the hands of the private entity. And the private entity itself may be considered a person responsible for public records for purposes of the Public Records Act. For in one example, the Ohio Supreme Court said that records of a private construction company were subject to the Public Records Act when a public office hired that construction company to build a publicly funded professional sports stadium. And specifically, this goes back to around, I think, maybe the turn of the millennium when they were looking to build a new stadium for the Cincinnati Bengals. Now, in another example, records of a law firm relating to its defense of a township was found to be public records because the township's duty to have legal representation is a public duty that the township delegated to the law firm. Now, note, though, when we're talking about this person responsible type of scenario, then it's only the work that they do for the government that is going to fall under the Public Records Act. Now, that being said, there is a scenario in which all records of a private entity are going to be subject to the Act. And that's when they are found to be the functional equivalent of a public office. Now, this has not been applied in a ton of different cases. I mean, I believe we're only aware of maybe about a handful or so. But essentially, the functional equivalence test says that if a private entity is performing a traditionally governmental function, then the entire entity, not just certain records that it produces, might be subject to the Public Records Act. Now, courts, when looking at this test, will ask 4 questions. Neither one is necessarily going to be dispositive. Now, 1, does the entity perform a governmental function? 2, how much government funding does the entity receive? 3, how much does the government control the private entity's day-to-day operations? And 4, was the entity created by the government or created to avoid the Public Records Act? Now, in contrast again to the person responsible test that we just talked about when we were talking about the Cincinnati Bengals Stadium, the functional equivalent test is much more narrow. Now, in one case, the 8th District Court of Appeals, which is up in Cleveland, found that a nonprofit organization that existed solely to raise funds for a public community college was the functional equivalent of a public office. The court reasoned that the foundation performed governmental functions because soliciting and receiving gifts and donations are going to be important functions of any college. Additionally, certain law enforcement entities have been found to be the functional equivalent of a public office. In this case, a campus police department was found to be a public office even though the college was a private university. The campus police officers were vested by statute with the same exact powers and authority that are vested in what we just traditionally think of police officers of a municipal corporation or even county sheriffs. The court there said that because the school's officers are sworn state-certified police officers who exercise plenary police power, then the campus's police department was a public office. Under this same exact reasoning, the Ohio Supreme Court found that the Cedar Point Police Department, which was responsible for providing security and policing at the amusement park, was the functional equivalent of a public office. Again, the police department there performed a governmental function because its officers provided law enforcement services and police protection on Cedar Point property. Now, interestingly, again, these are really kind of some recent cases because, again, it's very rare that this is going to be applied. All right, so that pretty much covers a public office. So what is a record? Well, you're going to kind of realize there's going to be kind of a rule of 3 where basically everything seems to have 3 parts of its definition. So the first is that it must exist on a fixed medium. Second, it must be created, received by, or come under the jurisdiction of a public office. And then finally, it documents the activities of the office. And let's start with our first one, which is a fixed medium. Fixed media is going to include things such as paper, photographs, audio and visual tapes, and calendar entries. But importantly, and probably most common in our age today, is that fixed media is also going to include electronic storage. So this means that things like emails, text messages, IMs, and other chat messages are all going to be stored on a fixed media. But a conversation or an idea, on the other hand, is not on a fixed media and are not record. So what's the takeaway? Well, if you really don't want to go ahead creating more records, instead of an email, go ahead and pick up the phone and call somebody. The second part of the definition is that to be a record is it must be created or received by or come under the jurisdiction of a public office. Now, the first parts of this about whether or not it creates or received is probably going to be pretty common sense in that it knows what it creates and it knows what it gets. But what does it mean to come under the jurisdiction of a public office? Well, let's just go about a few slides back and think about when I was talking about how private entities can be considered persons responsible for public records. Now there, the records are in the hands of the private entity, but the records come under the public office's jurisdiction. So that's really what we're talking about. Now, the final part of this definition, and the one that probably gives the most people headaches, is going to be the documenting activities of the office. So this means that the record must document either the organization, policies, decisions, procedures, operations, or any other activity of the office. Courts, when looking at this, will sometimes ask whether the record sheds any meaningful light on the office's functions and whether disclosure of the record would help monitor the conduct of that office. In other words, does the information or content of the record tell us something about what the public office actually does? Now, the answer to this question a lot of the times is going to be pretty clear, but we're finding a lot that the answer is a lot of times no. So let's look at some kind of textbook examples of something that does document and something that does not. So let's look at this first email. Now, for purposes of this example, let's say that it's sent from an official work account to another coworker's work account. And as you can see here, the employee is merely asking whether or not they're still on from the same lunch plans that they had earlier. Now, does this tell us anything about what that public office is really doing? No, it doesn't. Whether or not they go to lunch or where does not shed any meaningful light. Now, let's look at this second example. Again, we'll keep the same exact facts, except here they're talking about a financial report. Now, is this something that documents the activities of the office? Yes. Financial operations of an office are going to be one of the most probably important functions of any government entity. Therefore, this would be a proper public record that would be subject to disclosure. Now, we're going to be saying this a lot, but let's think about, would the example have changed anything if it was coming from a personal email address or maybe a personal cell phone? What if it was done in a text message, not an email? What if they're just chatting about the financial report on messaging things such as Facebook Messenger or Teams or Skype? Well, to answer all of these questions, you need to keep in mind one principle, and that's whether a record documents the activities of the office is determined by the information or content of the record, not by the record medium or whether it was or is stored on a personal device or account. And you're going to see me talk about that and say that over and over again. Again, it doesn't matter where it's stored. If you're talking about government business, even on your personal cell phone, then that is a public record subject to disclosure. So let's look at some real life examples. So in applying this rule, Ohio courts have consistently found that emails on an employee's personal account or device are public record if the content of the messages documents an activity of the office. And the same is true with text messages. In one example, there was a request made for text messages exchanged between 5 city council members. The council members were texting about whether or not they should fire a particular city official. When they received the request, the city denied it, arguing that because the messages were stored on the council members' personal phones, the records were not public. But the court disagreed and said that there is nothing in the Public Records Act that is going to allow a public office to treat records on personal devices any differently than it would from another item. Instead, again, the important question is whether the information in the messages documents a function, policy, procedure, operation, or other activities of the office. Now, going back to those text messages example, they were talking there about an employment decision of the office. Thus, that is clearly going to document an activity for that office, and it had to be disclosed. But don't worry, not everything that you do is going to be a public record. Now, if information is purely personal, then it's not going to fit under this third part of the definition. So let's go back and think about that email that was just up a couple of slides ago asking about a coworker's lunch plans. Now there, even though the employee is between 2 public employees and was sent on official employee accounts, the actual content of the email is purely personal and thus does not document any function, policy, operations of the office. So in that case, the public office could either decide to withhold that document, or if they want, they can go ahead and disclose. It's really up to the public office. And we'll go into that in more detail in a little bit. Now, just because you have a record in your possession as a public office does not necessarily mean that it is a public record for the purposes of the Act. Now, the important issue, again, is whether it documents the activities office and how the office uses that record can come into play. In one example, a judge was deciding how to sentence a defendant in a high-profile criminal case. The case garnered a lot of local media attention, and several people sent the judge letters trying to influence her decision. A request was made for the letters, but the request was denied. Now, on review, the court said that the letters were not public records because the judge did not actually use them when imposing the sentence. Specifically, the letters were unsolicited and just put in the judge's mailbox when they came in. The judge never looked at any of the letters and did not consider them at all when deciding how to rule. So there, the court reasoned that because the letters were not used, they did not actually document the judge's sentencing decision or any other particular activity of her office. In another example, a police department employee emailed another employee using his work email account and made racist comments about a third coworker. This coworker then heard about the email and made a public records request for it. The police department denied the request, and the court agreed and said that it was not a public record because it did not document any activity of the police department. Now, everyone agreed that the content of the email was reprehensible, but that being said, it did not document any function or operation of the office. Rather, it was merely a personal statement by one employee. But here's where it gets important. The police department did not use that email. And the outcome of the case very well probably would have been different had the email been used to discipline the person who had made the racial comments. So let's look at a case where that's exactly what happened. So in this other example, a teacher sent an inappropriate email during school hours. and she was disciplined for sending the email, and the email was used as evidence in that process. Because the school actually used the email to discipline the teacher, the email then did document the functions and activities of the office and had to be produced subject to a public records request. Sorry, 1 second, folks. All right, and accidentally skipped ahead a couple of slides. Now, how an office uses a record is also important when looking at notes and drafts and whether those are public records. Now, not everything a public employee writes words on becomes a record of the office, but notes and drafts can be records of a public office depending on how they're used. The bottom line is this, is that each note or draft might be a record or it might not. And you're going to go ahead and apply the definition of a public record to each document separately to determine this. Now, a note might be something as simple as a Post-it note that reminds you to return a phone call, or maybe notes that you have taken in a meeting to remember what was discussed. Now, to determine whether these are records that must be produced, courts are generally going to consider 3 factors. 1, are the notes personal? 2, were the notes used solely for the employee's personal convenience to recall events? And then finally, whether anyone else used them at the public office. Now, applying these factors in one example, a court found that notes taken by a city employee during another employee's pre-disciplinary conference were not public records. Going through the 3 factors, the court found that the employee used the notes for his own personal convenience to recall events, and there was no evidence that any city official or other employee used or accessed the notes. In another example, a court found that notes of a township employee who used to record his time before entering it into the online time management system were not public records. There again, the employee used the notes for his own personal convenience, and no other township official used or had access to them. Now, drafts are going to have similar issues. And when we're talking about drafts, we're talking about things that, even though they might not be in their final form, can also be subject to the Public Records Act if they otherwise meet the definition. There is nothing in the Public Records Act that limits a public office's obligation to provide only the final versions of records. But again, like notes, if the draft was kept for personal use, then it might not be a public record. But if a draft is circulated and shared with others, then it could be a public record that must be produced. The last part of the definition of a public record is that it must be kept by a public office. Now, if a record is retained by the office to carry out its duties and functions, then it's probably kept by the office for purposes of the Public Records Act. If the office has not created or received the record, then it's probably not kept by the office and is not a public record. Now, we talked earlier about how emails and text messages on a personal account or device are public records if the content of the message documents the activities of the office. Courts have also held that these records are kept by the public office even though they might be stored on a personal account or device. Text messages or emails on personal accounts or devices are treated like all other records if the messages document the functions, policies, procedures, operations, or other activities of the public office. Importantly, the kept by part of the definition of a public record means that if a public office has no obligation to produce records that it destroyed pursuant to a records retention schedule. The flip side of this coin is that if the office keeps a record past the date when it could have been destroyed, and there's a request made for that record while the office still has it, then the record is still subject to the Public Records Act. So what's the message? Well, keep up with your disposal schedules, and you're going to be able to reduce the volume of records you must produce and request. Just to give you guys kind of like a real life example, one time a few years ago, I was handling a public records request where there were tens of thousands of responsive documents. There, the public office could have destroyed thousands of documents as they had met their retention schedule. But because they did not, we still had to go ahead and provide all of those records. So let's go ahead and take everything that we've talked about today and put into practice to determine whether or not certain things are public record. So let's go ahead and call this a picture of my calendar. And it's something that a lot of employees are going to be using for work purposes. Well, is this calendar entry a public record? Let's go through the different parts of the definition. 1, is it on a fixed medium? Yes. It's probably going to be stored on the employee's computer. And therefore, it also meets the part that it is kept by the public office. But does the calendar document the activities of the office? Well, it does in some aspects. As we can clearly see here, the employee uses this calendar to keep track of certain office-related duties. There's things like payday, section meeting, another meeting, a financial report deadline, and then a public records training. But that being said, there's also parts of this calendar that are purely personal and do not document the activities of the office. And these would be the entries for the gym, the dentist appointment, and happy hour. Now, even if an employee goes to the gym every Tuesday at 5:30 or went out for drinks after work, this doesn't tell the public anything about the operations or functions of the employee's public office. So let's look at a different example. Now, this is slightly different than our emails that we saw earlier. Now, again, it's sent from the employee's work email. Well, we know that emails are on a fixed medium and are also kept by the public office. So again, does it document the activities of the office? Well, at a minimum, the first part of the email clearly documents the activities of the office because it's talking about responding to a public records request that the office received. But the second part of the email appears to be purely personal. Now, I know we all love a good true crime podcast or TV show, but talking about it does not tell us anything about the functions or operations of the public office. So let's go ahead and consider this same exact message, but let's look at whether it were to come from a personal account. So here, this is now from a personal Yahoo email. Does it change the analysis? Well, it doesn't. Again, it's on a fixed medium and it's kept by the public office because it's kept by the employee. And it talks about something that documents the activities of the office. Again, the responding to or the public records request. But the second part does not document activities of the office. So you would be able to redact this part of the email, but only this part of the email. Let's change the example again. This time, instead of being an email, let's make it a text message on a phone. Does this change the conclusion that it's still a public record? No. And like I said a few times already, it doesn't matter if this is on a personal phone or an office-issued phone. Because at least some of this text documents the activities of the office, it's a public record. So let's go ahead and let's switch gears and talk about the requester and requests themselves. So the first thing is that it's important to know that in Ohio, any person can make a public records request. This includes a person from another state or even from another country. Further, the word person does not just mean human being. Rather, it can mean a corporation or something that we see all the time, government agencies. It could also be a media outlet, which is, again, one of the more common types of requesters of public records. The Public Records Act is clear that a person can make a public records request either verbally or in writing, whichever the requester chooses. Again, most of the time, the Public Records Act is going to favor the requester. So this means that a public office cannot require a requester to put their request in writing or require that a requester use a particular form to submit a request. For example, some offices may offer records request forms, kind of like what we're seeing on this slide. Now, this could be a link on a website that allows a requester to submit a request electronically. And although these forms are certainly going to be convenient for both the office and the requester, importantly, the office cannot require that the requester use this form. Another thing is that the requester does not have to refer to the Public Records Act by name or use any other magic words to be entitled to records. For example, everyone knows and has probably heard of the Freedom of Information Act, which is a federal law. Now, although that's federal and doesn't apply to Ohio, if they refer to it, treat it like it's making a public records request. And when you might be unclear as if someone is making a public records request at all, it's always going to be best to err on the side of treating it like a public records request and go ahead and respond accordingly. Excuse me. Now, generally speaking, both the identity of a requester and their motive for asking for records is going to be completely irrelevant to the analysis. In other words, it does not matter who the requester is and why they want public records. This means that a public office cannot require a requester to give their motive or reason for asking for records or even the intended use of the records. For example, a requester might ask for records for a research project, to write a newspaper article, or maybe out of pure curiosity. Something that might shock a lot of people is that a requester might ask for records to dig up dirt on a public official, or maybe to embarrass the public office. And unless it's otherwise prohibited by law, a requester can get public records to resell for a profit. The motive of the requester does not matter at the end of the day, and the public office is not even allowed to ask for that motive. The next part of this slide shows that a requester can even be anonymous. They might use a pseudonym or maybe create an anonymous email account to make the request. You know, it sounds kind of funny, but if someone says their name is Mickey Mouse or Batman, you better go ahead and get that mouse or that superhero their records. Now, as a practical matter, while requesters can be anonymous, you should really make sure that you have some sort of contact information for the requester so that you can either supply them with their records or let them know that the records are ready to be picked up. Now, the Public Records Act does make a small exception to this rule that can be helpful to you. Now, the office is allowed to ask for the identity, intended use of records, or for the request to be put in writing if and only if the office believes that that information is going to benefit the requester by enhancing the ability of the office to identify, locate, or deliver the public records. Now, that being said, the public office must make it clear to the requester that disclosing their name, intended use of the records, or putting the request in writing is not required under the Act. Now, there are going to be some limited situations when the identity of the requester does matter. And that's because the Public Records Act allows some requesters broader access to certain records that's not going to be available to others. And the first of these examples is when the requester is a journalist, then he or she can access certain records that others cannot. For example, they're allowed to inspect certain coroner's records when others are not. Journalists can also see the residential address of peace officers, firefighters, EMTs, and other safety officers that are identified in that exception to the Public Records Act. Now, journalists, though, have to make their request in writing. They must also identify themselves by name, title, and the name and address of their employer. The request also has to state that the disclosure of the information sought is in the public interest. Now, luckily for us, as I put in quotation marks, journalist is defined under the Act and is defined as someone who is engaged in any news medium for the purposes of disseminating information for the general public. Like I said, this really doesn't help us out too much, as this definition is incredibly broad and it's not going to be limited to what we think of traditionally as maybe a journalist working for a newspaper or a TV station. Rather, it's probably going to extend also to online bloggers or any other individual who engages in any news medium to disseminate information. Two other examples of people who kind of get more access to records compared to others are insurance companies and next of kin of a deceased individual. They can actually see photographs of the decedent and certain notes and observations of the coroner when others cannot. Now, the identity is also going to be relevant if the requester is an inmate seeking records about a criminal investigation or prosecution. Now, in this situation, an inmate must get approval from his or her sentencing judge before having access to these records. The request must be filed in the inmate's original criminal action, and a public office does not have to produce the records until the inmate has received this approval. But again, it's important to highlight that this only applies if they're asking for criminal records related to investigations and prosecutions. If they are asking for anything outside of the criminal records context, then inmates must be treated like all other requesters. Now, the Public Records Act allows a requester to access their public records in one of two ways. The first, which is kind of the rare version, is through in-person inspection, or more commonly is the second, and that's by receiving copies. No surprise, the requester gets to choose what option they want. Now, there are a few ways that a public office's duties and responses to a request might differ depending on whether the requester wants to inspect records or merely wants copies. And the first difference is the public office's response time. For example, if the requester wants to inspect records, then the records must be promptly prepared for inspection. Unfortunately, promptly is not defined anywhere in the Public Records Act, but the Supreme Court of Ohio has said that promptly is going to depend on the facts and circumstances surrounding the request and the capabilities of the office. Now, if the requester wants copies of records, then the public office must produce the records in a reasonable period of time. Now, little spoiler alert, there's also no definition of that. But we'll go ahead and we'll talk a little bit more later about what reasonable period of time means here in a second. The second difference between responding to a request for inspection versus responding to a request for copies is whether the public office can actually charge the requester. Now, if the request is to inspect records, then the office cannot charge the requester at all. And this is true even if there are substantial personnel or retrieval costs to the office in producing the records. However, if there is a request made for copies, then the public office can charge the requester, but, and here's the important thing to take away, it's only for the actual cost of providing records. So what do we mean when we're talking about actual cost? So these are going to include the things such as the cost of the blank medium the record is on, such as paper or a disk or maybe a flash drive. It's also going to include the cost of ink and toner, and then the costs of packing, delivering, or transmitting the records. But that being said, an office can only charge the actual cost associated with providing the final copy to the requester. So this means that actual cost will never include things such as employee time or office overhead. And I know that that's, a big negative, but it's just a fact in a situations that public offices just have to deal with. Now, a public office can request that costs be paid in advance, but they have to specifically identify what the actual cost of the copies will be in advance so that the requester can decide whether or not he or she wants to pay. Now, whether or not a public office wants to charge anything is going to be completely up to that office. In some instances, it's probably in the office's best interest not to charge the requester. For example, it might be the effort to recoup costs might be more burdensome than it's worth. Like, think about it. What if the actual cost is only 75 cents? Is it really worth it to fight the requester? Maybe not. And also, not charging is going to promote goodwill with requesters. Now, we do want just you guys to be aware that there are certain statutes that are going to allow offices to charge more than actual cost. For example, the Bureau of Motor Vehicles can charge $4 for accident reports, and coroners can charge 25 cents per page, even though that's more than the actual cost of the records. If you think you might be subject to any one of these statutes, make sure you contact your legal counsel to make sure that you're not going against the Public Records Act by charging more than the actual cost. So let's talk about when they want to inspect records. So what are the public office's obligations? Well, they need to go ahead and arrange a time and a place for the inspection, even if the office is in a building with restrictions on who may enter all or part of the offices. I think a good example to kind of think of here is, a police department. You're probably not allowed to go into a police department's evidence room. Another thing that the office is required to do is to allow inspection at all reasonable times during the regular business hours of the agency. Now, regular business hours means all times that the agency is performing its formal duties. But that being said, there are a ton of different agencies that operate 24 hours a day, such as a police department or a fire department. Well, there, by reasonable times, what we mean is the administrative hours of an agency where administrative staff are available. Now, if the requester wants copies of records, then again, the requester gets to choose the medium on which they'll get those copies. Again, another example, Public Records Act favoring requester. So the requester may ask for paper copies or maybe electronic copies on a thumb drive or any other medium that the record is kept on. And if the requested medium is reasonably available to the public office in their normal operations, then the office must comply. So what does this mean? This means that if the record is in Excel format, it must be produced in Excel if that's what the requester wants. A lot of the times when we're handling public records requests, we might go ahead and convert everything into a single PDF file. Well, that would include an Excel spreadsheet. Thus, if we found ourselves in that exact situation, we would have to go ahead and provide the spreadsheet in Excel. Finally, the requester gets to decide how they want their records delivered. Most of the time, records are sent electronically in an email or maybe uploaded onto a cloud platform. But for one reason or another, a requester may want the records mailed to them or even hand delivered. And if the method chosen by the requester is reasonably available to the office, then the office must comply. A public office is not relieved of the duty to provide copies of public records just because the records are available somewhere else. So this means that even if the requester could go to a web page or another source to get the records, the public office cannot refuse to provide copies. In other words, if a requester asks for a copy of a report that could otherwise be downloaded from the public office's web page, then the public office can't simply direct the requester to their web page and refuse to produce a copy of the report. Let's use what's on the slide here as an example. So here, the Attorney General's office actually puts all of news releases it issues on the web page, and then anyone can view, print, or even share them. But that being said, if someone makes a public records request for a copy of a news release to our office, we cannot tell them that they can just go get it themselves on our webpage. Now, we will probably go ahead and tell them about the webpage as a courtesy and as an FYI, but we will still go ahead and provide them with the paper copy or electronic copy that they've asked for. Another example where we see a similar type of thing is when the same records are available at another public office. It's often the case that more than one public office has the same records, and a requester can ask any of those offices for the same records. And even if the requester has already got the records from one office, another office is still going to be obligated to respond and provide copies if it has them. Now, maybe a request is made to an office that does not have the records, but the office knows that another office does have them. For example, if a request is made to a state-level office for records that the state office does not have, but knows that a county agency maintains those records, then the state office can go ahead and deny that request, but can, as a courtesy to the requester, tell the requester where it might ask for the records. This is something we do all the time. For example, 2 days ago, we received a request asking for records of the Ohio Department of Insurance. We do not have any such records, but as an FYI, we made sure we went ahead and let the requester know that, hey, it seems like you're asking for things that are going to be held by this other entity. You should go there. At the end of the day, it's never a bad idea to communicate with the requester and let them know, best how they can get their records. All right, so now let's go back to the issue of response time. Now, as we said earlier, if you are asking for copies, then the public office has a reasonable period of time to respond. But what do we mean by that? Well, it's not going to be defined in the Public Records Act, but rather is going to depend on the facts and circumstances of the request. For example, does the request involve a large volume of records? Does it involve older records that may take longer to retrieve? Are extensive redactions required? Or is any legal advice necessary? Now, a court might look at one, any, or all of these things to decide if the office responded in a reasonable period of time. So to better understand this, let's go ahead and look at a couple of examples. Now, first, let's consider a request for a recently issued press release. Now, a recently issued press release should be easy for a public office to find, and because it was already issued to the press, it won't require any legal review or redactions. So for this request, the public office should be able to respond very quickly. Let's contrast this with a request for an old litigation file. Now, the file might be stored off-site or maybe in hard copy that it's going to take a lot longer to review. Because it's a litigation file, it's very likely that a careful legal review will be necessary to look for things such as attorney-client privilege or trial preparation records, which are exempt from disclosure under the Act. Now, this type of request is certainly going to take a lot longer to respond to. Long story short, there is no simple answer to whether a public office responds in a reasonable period of time. If a public office is sued because a requester thinks that the office took too long to respond, then the court must do a thorough analysis of the facts and circumstances of each request. So let's go ahead and look at some real-life examples. So one of the factors that can come into play is the type of records requested. So if we're looking at that press release that I just talked about, that's a type of record that the court would expect to be produced quickly. Another example is resumes or job applications for jobs in a public office. In one example, a requester asked a school district for candidates' resumes submitted for an open treasurer position. The school district took only 6 days to produce the resumes. And that seems pretty reasonable, doesn't it? Well, the court said no, and that the district's response time was unreasonable. The court reasoned that resumes of candidates for a public position do not fit within any exemption, and applications for public employment are always subject to disclosure with only some limited redactions. Now, in another case, a requester asked a police department for copies of all car accident reports for a single day. The city took 24 days to produce the reports. There, the court said that 24 days was unreasonable. Like the resumes in our previous example, accident reports would only need a few, if any, redactions and are a type of record the office should be able to produce quickly. Now, the circumstances surrounding the request are also something that a court will probably consider when deciding if the office responded in a reasonable period of time. Now, if you've lived in Ohio at all in the past decade or know someone from Ohio in the past decade, then everyone will probably remember the Pike County Massacre in 2016. There, 8 people, all members of the same family, were shot and killed. A crime like this was unprecedented in Ohio, especially in the small county of Pike County, and there was significant media attention that followed. Very quickly, 2 newspapers made public records requests for the autopsy reports of the victims. And the Pike County Coroner's Office took 2 months to release redacted versions of the reports. There, the court found that 2 months was reasonable based on the magnitude of the investigation and the need to redact the reports with care given the sensitive nature of the case. Now, more recently, courts have looked at whether the COVID-19 pandemic justified an office's response time. And in that case, a city said that it delayed responding to a request because the person assigned to respond could only get into her office 1 day a week. The request came in May of 2020, but the office did not fully satisfy the request until that September, importantly, after it was sued. The court said that while it was certainly sympathetic to the difficulties caused by the pandemic, over 2 months lapsed between the date of the request and the city's first production of records, and then 4 months elapsed until the city's response was completed. And the city was suddenly able to fulfill the request after it was sued. Now, how a public office communicates with the requester is important to how a court decides if an office's response time is reasonable. So in one case, a requester sent the public office 42 separate requests over the course of 6 weeks. The requester wanted 14 personnel files and time off requests for 6 employees. The public office did not communicate with the requester at all for 2.5 months after the request came in, and 22 business days after the requester sued the office. Not surprisingly, the court said that the office's response time was unreasonable. Now, Even though it was a large request, the court noted that the office never responded to the requester in any way for 2.5 months. And as a result, the court awarded the requester $3,000 in statutory damages. Now let's compare that case to another one where the requester asked a police department for several types of records, including internal policies, manuals, and regulations, as well as the personnel files, training certifications, and disciplinary reports for 9 officers. Now, within a month, the office acknowledged the request and told the requester that it would produce records on a rolling basis. The office updated the requester frequently, and the office produced the first set of records 2.5 months after the first request, but admittedly after the requester sued the office. So here, there is a similar amount of volume of records and a similar time frame as that previous case that we just talked about. But unlike in that last example, the court found that the office's response time was reasonable. And although it looked at other factors, the court gave a lot of weight to how the office communicated with the requester and its willingness to produce records on a rolling basis. As these cases show, whether a public office's response time is reasonable is going to depend on the facts and circumstances of each case. However, it's important to know that courts have made it clear that burden will never excuse an office's delay. This means that an office's delay is not justified simply because it will cost too much, take too much time, or interfere with the office's normal duties. This is true even if responding to a request will strain the personnel resources of the office, result in a large volume of records that will be a pain for the office to deal with, or if the office has a lot of public records requests at the same time from the same or different requesters. Despite any and all of these circumstances, the office's duty to respond in a reasonable period of time remains the same. So there's really 2 big takeaways from these cases that we talked about. First, don't backburner your public records requests. And second, communicate with the requester. Go ahead and acknowledge the request promptly and tell the requester that you've received the request and that you're working on it. If you think it's going to take a long time to fulfill the request, consider producing records on what we call a rolling basis by sending out groups of records as they're ready, rather of waiting until all the records are ready to go out. And continue to update the requester on your progress and communicate to them what you can. Like these 2 examples we talked about, a court is going to often look at your overall efforts and diligence in responding, including your office's communication with the requester. Finally, remember that if your office is sued because a requester thinks you didn't respond in a reasonable period of time, your office has the burden of explaining any reason for delay. Now, we've been spending a lot of time talking about what are the obligations of a public office when responding to a request. But that being said, there are several things that a requester must do to make a proper and enforceable request. First, a proper public records request must describe existing records. Now, records may not exist if the public records properly destroyed the records pursuant to its records retention schedule. And also, records do not exist if they were never created. Importantly, a public office is not required to create new records to respond to a public records request, even if it's only a matter of compiling information from existing records that might be readily available. But there is an exception to that rule. And that's that a public office is required to create records if the requester asks for information that's in a database and that the office can use this database to compile the information and create the requested record. What's an example? Well, let's say the requester asks for a copy of a report that lists the name, job title, and number of years employed for each employee of the office. Now, it's likely that the office does not have this type of report with all 3 pieces of information. But if the office has a database with all of its employees' information and could create a report with the requested categories without having to reprogram the database, then the office is required to create the report and produce it. The Supreme Court of Ohio has explained that if an office's database can perform a search and produce the requested record, then the record already exists for the purposes of the Public Records Act. Now, if an office has to reprogram its database to produce the requested record, then the record does not exist and does not need to be created. Long story short, make sure you go ahead and you talk with your IT department to know what are the capabilities of your database. Another limitation on requests is that a requester cannot ask the office to conduct what amounts to a research project or ask the office to search through records to locate a particular name or type of information. For example, a request for written confirmation of why, how, and when a videotape was destroyed was found to be not a proper public records request. In another case, a request for records supporting or explaining an office's decision was a request for information and not a proper public records request. A requester is also required to describe the records they want with reasonable clarity. This means that the wording of the request must fairly and specifically describe the records, and the burden is on the requester to do so. A requester must also identify the records they want based on the way the public office maintains and organizes its records. If a requester does not do that, then the request might be considered overly broad or ambiguous, and the public office can deny the request. Like other areas of public records law, whether a request is overly broad or ambiguous is going to depend on the facts and circumstances of the request. So let's look at a couple of real-world examples. Let's first talk about overly broad requests. Now, a request might be overly broad if it is so over-inclusive that the public office cannot identify responsive records based on the way it keeps its records. For example, if a requester asks for every memo that an office has drafted over the course of a year, their request might be overly broad if the office does not keep every memo filed together. For example, the office might keep memos according to subject matter or by specific section of the office. A court will look at several factors to decide if a public office properly denied a request is overly broad. And one of those is whether the request has a time limitation. For example, in one case, a requester asked a police department for all accident reports with no time limitation. The court there said that the request was improper because it was unreasonable in scope, and the indefiniteness of such a request renders it incapable of being acted upon. Even if a request does have a time limitation, though, it can still be overbroad if it asks for a complete duplication of an office's records or files. In one example, a court found that a request for all personnel files of an office was overbroad. In another example, a requester asked for all correspondence of one email over a 6-month period. Now, correspondence can mean a lot of things. It can be paper letters, memos, emails, or text messages. And even with the 6-month time limitation, the court said that the request was overly broad because it asked for a complete duplication of the agency's records. And the Supreme Court recently affirmed the importance of looking at all the facts and circumstances of each request. There, the requester asked for all emails between 2 employees and all emails to and from another employee over a 27-day period. The office denied the request and said that the requester was asking for a complete duplication of records because the requester wanted all emails with no search terms or subject matter. That being said, the court disagreed and said that a public office cannot simply outright deny a request whenever it asks for all of a type of record, or if the request does not include search terms or a subject matter. Instead, offices must look at each request separately. The court said in that particular case, the request for all emails was sufficiently narrow. Important to this issue is how the office organizes and maintains its records. In one case, the court said that a request for all emails between two employees over a certain time was overbroad because the office did not organize its emails by sender and recipient and therefore could not search for records in that way. And the request that we just talked about for all correspondence was improper because the office did not organize its records with all correspondence filed together and therefore did not have a way to search across all types of correspondence. In another case, a requester asked a police department for copies of all service calls for a geographic area identified by street names. But the department did not keep its services call records according to general geographical area. Instead, dispatch logs and service calls were stored in a database and could only be searched by party name, a specific address, or alleged crime, not by geographic area. The court said there that the department properly denied this request. A public office is required to organize and maintain its records so records can be made available to produce. And we're going to talk more about this requirement later on. But for now, just know that the Public Records Act does not require a public office to do this in a certain way. This means that an office doesn't have to organize its records in a certain way to be able to respond to a request, and the office does not have to organize its records according to how a requester thinks it should be done. Instead, requesters have the burden to make their requests fit the way the office keeps its records. This is true even if the office's organizational system is not the most efficient system, or if it makes responding to a request take longer. In one case, a requester asked a police department for reports from pawnbrokers, which the department was required to maintain pursuant to statute. At the time, the department organized these reports in a file of 3 by 5 inch index cards. To respond to the request, the department had to photocopy each card front and back. Now, even though the department responded to the request, the requester sued and said that the way that the department organized these reports slowed down its response. But the Supreme Court of Ohio disagreed. The court said that there were certainly better ways for the department to organize these reports, which would have made responding to the requester faster, but the department was not violating the Public Records Act by having an antiquated system. Now, another type of request that can cause issues are going to be ambiguous requests. Excuse me. A request might be ambiguous if it is so unclear the public office does not know what the requester actually wants or where to even look for responsive records. Or the requester might use language that's vague or subject to interpretation, and the office is put in a position of having to guess or make a judgment call about what records might be responsive. For example, if a requester asks for all records related to other public records requests, the office wouldn't know what records are, quote, related to the public records request it handles. Does the requester want copies of the requests made to the office? What about copies of records that were produced? What about the office's public records log? Do they want all of these things? Well, in one case, a court held that a request for emails between village officials, quote, concerning village business was ambiguous. What village business means is certainly unclear. It could potentially mean everything the village does. And what records do or do not, quote, concern village business is vague and subject to interpretation. But like overly broad requests, the office will have to look at the facts and circumstances of the request when making these decisions. Now, there are a few important things that a public office must do if it denies a request as overly broad or ambiguous. First, the office must give the requester a chance to revise the request by informing the requester of how its records are maintained and accessed. In other words, the office must explain how its records are organized and maintained so that the requester can resubmit their request after he or she has this information. Know that if a public office is sued, based on its response to a request, the office cannot claim that a request is ambiguous or overbroad for the first time in litigation. Why is this? Well, let's look on this slide. What's the first thing they have to do? They have to provide them with an opportunity to revise. So therefore, if you're bringing it up for the first time in litigation, then you're not giving them this second chance. Now, how an office explains how its records are organized and maintained will depend on how the office actually keeps its records. In our office, we might refer requesters to our records retention schedules to show the requester how our office is divided by section and how different categories of records are maintained within each section. We will also explain that generally speaking, the Attorney General's office organizes its records according to a case or topic. For example, our office got a request for all emails between the Attorney General and the Solicitor General during this current administration. We denied that request as overbroad because our office does not organize and maintain its records in a way that would allow us to identify all such emails. But we explained to the requester how we organize our records and that we keep our records according to a case or topic. The requester then revised their request and asked for emails related to a specific case, and we were able to respond and provide the emails. So the goal here is to help the requester narrow the request. Also keep in mind that if the requester challenges the office's response in court, then the court will look at the office's attempts to work with the requester to clarify the request. So here's an example response letter to give you a better idea of what a response to this request would look like. So let's go ahead and break this down to better understand each part. The letter starts by saying that what the request was for and when it was received so that it's clear what this letter is responding to. The letter states that the request is being denied because it is overbroad, and it cites the legal authority that supports this decision. The letter then explains how the office's records are organized and has links to the office's retention schedules. Sorry, skipped ahead a little bit. Finally, the letter invites the requester to revise and resubmit the request. Thus, again, you have gone ahead in this letter and you've done everything that you're required to do by law. So I think we've reached a good stopping point for this part of the training. So I have 2:16 on my watch. Let's take a 10-minute break and come back at 2:26. It's just 2:17. So we'll call it 2:27. And we'll go ahead and start talking about exceptions or exemptions to the Public Records Act. Okay, this is Mike back again. By my watch, it's 2:27. So to make sure we go ahead and we keep everybody on schedule, let's go ahead and go ahead and switch gears now and turn our attention to the topic of exemptions, meaning when a record or information in a record can be withheld or redacted. Now, there are numerous exemptions that apply to public records. Some are listed in the public records itself. Others come from state and federal statutes, administrative codes, or even case law. Now, importantly, exemptions can only be created through such legal authority. An exemption cannot be created by a contract, and any contract provision that attempts to exempt certain records or information from being public or attempts to make public information confidential will be void as a matter of law. In one case, the Supreme Court of Ohio voided a contract provision between a city and an employment search firm. The city was looking to hire a new safety director and retain the firm to help with that search. In the parties' contract, it said that all candidate applications and resumes were not subject to the Public Records Act. And the search firm also told any applicants that their information they provided would be confidential. However, the court voided this provision and made it clear that the Public Records Act is going to trump any contractual obligations. Another important point about exemptions is that they are always narrowly construed. This means that the starting point is that all records kept by a public office are public records. If a public office wants to withhold or redact information from a public record, then the office must show that there's an exemption in the law that allows them to do that. And the burden is going to be on the public office to articulate the claimed exemption and show that the withheld information clearly fits within the exemption. If there are any doubts, those doubts must be resolved in favor of disclosing the record instead of withholding. Now, there's two types exactly that. They're a mandatory prohibition on releasing the records or information. And a public office is not allowed to release the record information, even if it wants. And in some instances, there can even be criminal or civil penalties if the public office violates a mandatory exemption. Now, you're typically going to find mandatory exemptions in federal and state laws outside of the Public Records Act. And then the Public Records Act has a catch-all provision that incorporates these laws as exemptions to the Act. The second category of exemptions are called discretionary exemptions, which give the public office the choice to release a record. Now, unlike a mandatory exemption, there is no prohibition against releasing the record, and therefore there's not going to be a punishment under the law for disclosing. But the two categories are the same in other ways. For example, courts will always interpret both categories of exemptions narrowly, just like we discussed. Also, when a public office asserts either a mandatory or discretionary exemption, the public office has the burden to prove that the exemption applies. So this means that the public office must show that the records or information fit squarely within the exemption and can be redacted or withheld. So let's talk just very briefly, one slide of mandatory exemptions, just to give you kind of an idea. So one example of a mandatory exemption is FERPA, which for those of you that don't know what that is the Family Educational Rights and Privacy Act. FERPA is a federal law that puts conditions on schools that receive federal funding. One of those conditions is that the schools are prohibited from releasing student records and data with very limited exceptions. This law applies to a variety of educational records and applies to students at every grade level. Now, although there is no criminal penalty for violating FERPA, a school could lose federal funding if it improperly releases protected records. Another example of a mandatory exemption is the prohibition of the release of criminal history reports that are generated by the Law Enforcement Automated Data System, more commonly referred to in Ohio as LEADS. LEADS is a database that provides data and communications for criminal justice agencies across the state. Now, access to LEADS is very limited, and information gathered from LEADS is confidential. Under the LEADS statute, there are criminal penalties for improper release, and I believe currently it's actually a felony. So if a public office encounters records subject to any mandatory exemption, it's extremely important to consult with legal counsel, particularly again because some mandatory exemptions carry penalties for improper release. But most of your exemptions that you're going to deal with are discretionary. So let's go ahead and talk now about some certain exceptions that are discretionary. So one example is the confidential law enforcement investigatory records exemption, which is kind of a mouthful. So let's just refer to it as the CLEARS exemption. And this is going to generally apply to certain law enforcement investigation records. Now, a public office has to prove two elements in order for the CLEARS exemption to apply. First, the records must pertain to a law enforcement matter. Now, criminal investigations are obviously law enforcement matters, but that being said, CLEARS can also apply to quasi-criminal, civil, or even administrative law enforcement matters, so long as there is some sort of statutory authority to enforce a law. For example, one court found that the CLEARS exemption applied to state medical board investigations when it was investigating a physician's alleged misconduct in a disciplinary hearing. Now, CLEARS does not apply, though, to routine employee or personnel matters, even if the employer is an agency that has some sort of law enforcement authority. The second element that must be satisfied for the CLEARS exemption to apply is that the release of the records must create a high probability of disclosing certain types of information, including the identity of an uncharged suspect or a confidential source, specific confidential investigatory techniques or procedures, investigatory work product, and information that would endanger the life or physical safety of law enforcement personnel, a crime victim, a witness, or a confidential informant. Now, we're not going to cover all of these today, but let's look at a couple of these just to provide a little bit more clarity. So confidential investigatory techniques or procedures are going to apply to things like sophisticated scientific testing and forensic lab tests. The purpose here is to avoid compromising the effectiveness of proprietary and confidential investigative methods. But courts have rejected applying this exemption to routine factual reports. For example, the Supreme Court of Ohio refused to apply this exemption to witness interviews in an assault prosecution. The prosecutors there argued that interviewing sexual assault victims is a sensitive issue that requires special techniques and understanding of the victim's mindset. And in this particular case, the victim was a minor and the defendant who was convicted was one of her teachers. But the problem that the prosecutors had in this case is that they could not articulate the specific technique at issue or explain why such a technique had to remain confidential. So therefore, the CLEARS exemption did not apply to these records. Investigatory work product applies to things such as notes, working papers, or similar materials that are prepared by attorneys or law enforcement officials in anticipation of litigation and assembled in connection with an actual pending or highly probable criminal proceeding. Now, a criminal proceeding is probable or highly probable just so long as it's clear that a crime was committed. Like other discretionary exemptions, the investigatory work product exemption is applied narrowly and may only apply to just a small part of a record. For example, A request was once made for the dash camera recordings of the State Highway Patrol that occurred during a high-speed chase. The chase lasted about 20 minutes and was recorded by 3 separate patrol cars. The Highway Patrol argued that the entire recording was investigatory work product and should be exempt under the Clears rule. But the Ohio Supreme Court disagreed. The court said that most of the footage did not actually involve any investigative functions whatsoever, and the department policy required its troopers to record all pursuits and traffic stops, regardless of whether a criminal prosecution may follow. In other words, most of the dash cam footage was just simply routine. It wasn't necessarily assembled in connection with an actual or highly probable criminal case. Now remember, like I said, it could apply to maybe only a small part of the record. And that's exactly what was the case here, because the court found that 90 seconds of the recordings could be redacted. And that was when a patrol officer took the suspect to his patrol car, read his Miranda rights, and then questioned him. Now, these 90 seconds constituted investigatory work product because by informing the suspect of his Miranda rights, the officer intended to secure admissible statements for the prosecution's later use at trial. So in this particular case, whether the Clears exemption applied involved a frame-by-frame, second-by-second review of 20 minutes of footage. Now, one thing to keep in mind with the investigatory work product exemption is that it's time limited. Thus, when a law enforcement matter ends, the exemption ends and no longer applies. The Supreme Court of Ohio has found that the investigative work product exemption does not extend past the end of the trial for which the information was gathered. So this means that even if a defendant immediately appeals his case, once that conviction is issued and the sentence is issued, that ends the exemption's lifespan. Does not matter that an appeal of that trial takes place. But it's important to note, though, that this time limitation does not apply to the other types of investigatory records under Clears. For example, an investigatory record that falls under the uncharged suspect exemption will apply despite any later trials. Now, there are 2 categories of records that are often found in law enforcement matters that are not going to be covered by the Clears exemption. And the first are 911 calls. And this always gets me in trouble, I feel like, with certain law enforcement for these trainings. So 911 calls are not considered part of an investigation, so they are not covered by Clears. In fact, the Supreme Court of Ohio has held that these are always public, because when someone calls 911, they have no expectation of privacy and should assume that the call will be recorded and disclosed. So what does this mean? And here's the controversial bit. Even if a 911 caller discloses information about an uncharged suspect or even a social security number, that information cannot be redacted. I do just want to note, though, that this is only for the actual 911 call. If, for example, there's a report that's drawn up that summarizes the 911 call, these exemptions could apply to that particular record. Now, another category of records that do not fall under Clears are what's referred to as initial incident reports. Like 911 calls, these are not considered part of the investigation itself. Rather, the officer is only gathering information before an investigation begins. And the Supreme Court of Ohio recently addressed whether supplemental narratives that are attached to an initial incident report falls under the Clears exemption. As those in law enforcement know, incident reports frequently have one or more supplemental narratives attached. And in this particular case, the requester asked for police reports that included both initial incident report forms and supplemental narratives. The court said that supplemental narratives are not automatically considered part of the initial incident report. nor are they automatically considered to be separate and thus exempt under CLEARS. Instead, you must look at the nature of the content and when the record was created. As to the content, information that's considered incident information is not going to be exempt under CLEARS, whether it's found in the initial report or a supplemental narrative. Incident information means an officer's initial observations and witness interviews, or information that initiates the investigation. Now, incident information, even if it's in a supplemental narrative, is not exempt under CLEARS and must be produced. Now, information that's collected after the investigation is underway may be withheld under CLEARS as specific investigatory work product. Another factor that's important is when the narrative is created. For example, in the case that we're talking about, some of the supplemental narratives contained observer observations at the time they were responding to the incident and initial witness statements that were taken at the time of or shortly after the incident. But some of the supplemental narratives were created several days after the incident and contained information that went well beyond incident information. Now, this analysis is going to turn on the specific facts and circumstances of each case, and also will depend on the type of information in each part of the report and when it was created. Like other types of records that I've talked about today, what matters is the content of the record, not when it was created. And if you have any questions about whether a report or narrative can be redacted or withheld, you should talk to your attorney who represents your office. Note, though, that other exemptions can be applied in an initial incident report. Therefore, if someone gives an officer a social security number and they put it in there, that can be redacted. Another exemption, that's the two exemptions that are found in the same statute, is the security and infrastructure records exemptions. It's important to note that although they're in the same statute, they are two separate exemptions that apply differently. The first is the security records exemption. Now, security records are records that contain information directly used for protecting or maintaining the security of a public office against attack, interference, or sabotage. And the second part of this exemption is the infrastructure records exemption. This applies to records that disclose the configuration of critical systems, including computer systems, electrical and mechanical systems of a building, or even the infrastructure or structural configuration of a building. But it's important to know that the definition of infrastructure records does not include simple floor plans that disclose only the spatial relationship of components of the building. So let's look at a Supreme Court case that shows how these exemptions are applied separately. Let's look at the security records first. In one case, a requester asked for copies of a prison shift's assignment duty rosters. The rosters showed where guards were posted, which guards are assigned to a particular post, and how many will be there at a given time. The court there found that the rosters were security records because knowing where and when guards would be posted could be used to plan an escape or an attack or smuggle contraband into the prison. In another case, the Supreme Court found that video that captured the shooting of a judge was not a security record. The footage there was from an exterior courthouse security camera and showed the judge being shot as he was going into the courthouse through a non-public secured entrance. The court there looked at how the office used the footage and found that there was no evidence that the footage contained information that was directly used for protecting or maintaining the security of a public office against attack, interference, or sabotage. Now, recently, you guys might remember that Governor DeWine attended the Super Bowl when the Cincinnati Bengals made it. Well, there, the Supreme Court found that the travel records for the governor's security detail were security records. For example, the records showed things such as how many troopers were on the detail at one particular time, how they traveled, and when they traveled. the court held that releasing the records would reveal patterns, techniques, or information relevant to the size, scope, or nature of the security and protection provided to the governor and could be used to attack, interfere, or sabotage the governor or his security detail. Now, let's switch gears and talk about infrastructure records. So, in determining whether or not records are considered infrastructure records, courts are going to look at what systems the records reveal. For example, a state correctional institution claimed that security camera footage that documented a use of force incident was an infrastructure record. The Supreme Court of Ohio disagreed because the video showed no more than what could be learned from a simple floor plan. They highlighted that the footage did not show the location of a fire or other alarm, where officers were posted, or the configuration of any other critical system. Now, in the case that we talked about in the previous slide about the prison shift assignment rosters, the court found that these rosters were not infrastructure records because guard assignments and locations are not systems like a mechanical or electrical system, and the assignment of guards in the prison does not relate to the structural configuration of a building. But again, like we just talked about, the court found that they were security records, though, and could be withheld. Now, public offices and employees and just anybody else are sometimes surprised to learn that there are no general exemptions for certain categories of records. For example, there's no general exemption for government job application materials that public offices maintain for every employee. These may include things like civil service forms, resumes, references, writing samples, polygraph examinations, and fitness for duty reports. In fact, the Supreme Court of Ohio has said that the public has an interest in reviewing the qualifications of potential applicants for government positions. However, a public office can withhold otherwise exempt or non-record information contained in these files, such as social security numbers and home addresses. There's also no general exemption for juvenile records. Just because a record has a child's name or address or other identifying information does not mean that these records can simply be withheld in their entirety. Now, there are specific exemptions that apply to specific types of records, such as those maintained by juvenile court. But juvenile offender investigation records maintained by law enforcement agencies, generally speaking, are treated no differently than adult records. Finally, there's no general constitutional right to privacy that applies to exempt public records. And the right to privacy has been applied to exempt some records, but only in very, very limited circumstances. Now, it's important to note that a discretionary exemption can be waived by the public office if it chooses to release a record that might be subject to a discretionary exemption. For example, if a police department gives a report to one requester and someone else asks for that same report, then the department cannot claim that the report is now subject to clears and withhold it. However, it's important to note that an initial disclosure must have been done voluntarily. So therefore, if we use this example again, if the same police department had accidentally released the report, then that's not a voluntary disclosure, and the department has not waived the ability to invoke the clears exemption in that scenario. Now, the list of exemptions is long and too numerous for us to talk about every exemption that exists. And it's very possible then that more than one exemption can apply to a record or to information contained in a record. Thus, when you are reviewing records, it's important to look and consider all exemptions that might apply and talk to your legal counsel to make sure that these exemptions are properly applied. Finally, know that if an office cites an exemption as the reason for denying a request, but later turns out that there might have been another, perhaps even better exemption that also applies, then an office can still assert the other exemption later including after the requester sues. Note, though, that this is not going to be true if an office is claiming a request is overbroad or ambiguous. Excuse me. As we talked about earlier, a public office cannot claim that a request is ambiguous or overbroad for the first time after it's sued. And this is because the office must give the requester a chance to revise the request by informing the requester of how the office's records are maintained and accessed. This same rule does not apply when a public office applies any other legal exemption. So if a public office decides that an exemption applies, then the office can do one of two things. It can either redact or withhold the exempted information. Now, if an entire record is covered by an exemption, then the record can simply be withheld. But if only parts of a record or some information contained in a record is covered by an exemption, then only that specific information may be redacted. For example, if one sentence in an email is protected by attorney-client privilege, then only that one sentence can be redacted. Now, earlier we talked about whether the information or content in a record documents the activities of the office. For example, employee home addresses, generally speaking, do not document the activities of the office and are not public record. Now, there are two exceptions to this rule, and that's when a person's home address is the same as his work address. Now, I know that the pandemic has complicated that, so don't necessarily come up to me and ask me, oh my God, I work from home now. Does that mean that my address is the same as a work address? Off the top of my head, I am not sure, but I know as an employee who works from home, I still have a work address in that it's, in the downtown Columbus building. The other example of when a home address can be considered a public record is if the employee is required by law to live in a certain geographic area in order to work in that particular job. So this type of information is considered non-record and can be redacted or withheld in a public records request. So you might typically find an employee's home address in a personnel file or even on a civil service application form. Now, both of those, meaning a personnel file and a civil service application form, are clearly public records that must be produced. But the non-record information contained in those records, such as the employee's home address, can be redacted as non-record. Non-record information is not necessarily confidential, though, and does not always have to be redacted. You might remember our earlier email that documented the activities of the office, but then also contained some purely personal information about lunch plans and true crime podcasts. Well, these latter two things that are purely personal can be redacted as non-record, but the public office could decide that they just want to go ahead and release the entire email without redacting the non-record information if that is what the public office so chooses to do. So, what are your obligations when you're redacting? Well, there are a few important requirements that public offices must follow in these situations. First, redactions must be plainly visible. So if in the last sentence of an email falls under exemption, you can't simply white out the sentence so that it looks like the sentence was never there. Rather, it must be clear to the requester that the sentence was redacted. And the easiest way to do this is to cover the sentence in a black box. I'm going to presume that most of us, if not all of us, have seen like an action movie. And if you just kind of go and you're watching that movie and all of a sudden, the CIA comes and hands somebody their confidential, manila envelope, they'll open it up and they'll just see paper after paper that's, blacks out everything in Sharpie except for the words the and a. That's essentially what you need to do in redacting anything that's subject to an exemption. Now, the second requirement that a public office has to do is that it must tell the requester that a record or information has been withheld or redacted, and the office must explain the legal basis for the redaction and then cite to the applicable legal authority. So, for example, let's say that a public office redacts a social security number. Well, in the office's response to the requester, the office is going to have to state that information has been withheld pursuant to Revised Code Section 149.45, which is the statute that protects Social Security numbers from public disclosure. Now, had this exemption been created in case law, then the public office would have cited the case in its response. To make things easier for your office when redacting records or information, or maybe when deciding if exemptions apply, we recommend that you keep a public records request cheat sheet or list of common public records issues that you face. For example, most offices get requests for an employee personnel file at one point or another. Now, if you have a list of exemptions and issues that are commonly found in personnel files, then responding to those requests is a lot easier. Now, on this slide is a sample personal file cheat sheet that is actually in our Sunshine Laws manuals that offices can use. So let's go through some example records to better understand how exemptions and redactions work in practice. So what we have here is an employment record, specifically the Ohio Civil Service application for state and county agencies. Now, we've talked about how government job applications and how these are public records. So therefore, we have to decide if there's anything on this application that can or must be redacted. Well, let's first look at the candidate's address, phone number, and email. If all of this is personal information, then can it be redacted? Well, yes, it can, as non-record, because it does not actually document the activities of the office. Note again how it's covered in a black box, again, looking kind of like that CIA report. Now, what about a driver's license number? Well, the Public Records Act exempts from definition of public record personal information as defined in the revised code. And if we were to pull up that statute and look at the definition of personal information, we would see that personal information includes an individual's driver's license number. So therefore, we can redact it. Now, if your office has that cheat sheet that we talked about earlier for employment records, then this information would be at your fingertips and make responding to these types of requests pretty straightforward. Last, again, just to highlight, the redactions are plainly visible, so therefore the requester can see that this record was redacted. Now, when the public office produces this record with redactions, we know that it must explain to the requester that redactions have been made and then give the legal reason for the redactions. Now, this is an example of a letter that the public office could include with the responsive records. The records state what the request was for and when it was received so that it's clear again what this letter is responding to. The letter then informs the requester that certain information was redacted because it's not a record of the office. A case is cited, and it tells us that non-record information such as personal cell phone numbers, email addresses, and home addresses can be redacted. The letter also cites the statute that states that a driver's license number is personal information that is exempt under the Public Records Act. So let's go ahead and look at a few examples of what we've already talked about and see how redactions apply to these records. So first we have that calendar entry that we saw earlier when we were talking about whether or not information documents the activities of the office. And we know, though, here that there are certain things that do document the activities, such as the payday financial report and things like that. But there's also things that are purely personal and do not document the activities of the office. Therefore, the gym, dentist appointment, happy hour can all be redacted as non-record information. Here again is the same email we also saw earlier. Like the calendar entry, this record has some information that documents the activities of the office and some information that does not. The second sentence of this email, like we talked about earlier, is purely personal and does not document the activities of the office, and therefore it can be redacted before it's produced. So here's an example of a letter that could be used to include responsive records for both requests. Again, it states what it's responding to, talks about how certain information was redacted, it provides the reason, and then gives the case that supports that as well. Now, it can be the case where an exemption applies to not just a portion of a record, but rather the entire record itself. And therefore, it can be withheld in these situations. One example is a medical record, which we see here. Now, this kind of record might be found in a personnel file or some other type of employment record. Well, the Public Records Act exempts medical records and applies to any document that pertains to the medical history of a patient that's generated and maintained in the process of medical treatment. So if this entire record falls under the definition, then the entire record can be withheld. Now, practically speaking, you don't necessarily need to provide black pages to show that something is withheld. So long as you indicate in your response letter that you are withholding documents based on a particular exemption and provide that information, then you're fine to do that. So here's what that letter would look like. Again, says what it's responding to, says that it's withheld records rather than redacted, and then provides the legal reasoning that supports that claim. The final point on the topic of exemptions is that a public office must redact and withhold information in good faith. This is important to remember because if a public office is sued over its decision to withhold or redact a record, the public office has the burden of proving to the court that the records are exempt. If your office has any questions or doubts about whether specific exemptions apply, contact your office's legal counsel for advice. This is particularly important because, as we've mentioned, mandatory exemptions can have penalties for improper disclosure. Discretionary exemptions are frequently interpreted by courts and can change. And some exemptions, such as the attorney-client privilege, are very nuanced and can be difficult to know when or when not it applies. Also, the General Assembly amends the Public Records Act frequently, so you'll want to make sure that you have the most up-to-date information. All right, let's switch gears and talk about what happens when things go wrong. What happens when a public office takes too long to respond to a request, or maybe doesn't respond to a request at all? Or if the public office withholds records that the requester thinks should have been produced. The requester can sue the public office for violating the Public Records Act and has two avenues to do so. First, the requester can bring a mandamus action, and second, the requester could bring a special court of claims action. Now, the choice is up to the requester, and a public office cannot force a requester to litigate where the public office chooses. Again, another example of how the Public Records Act is going to be more favorable to the requester. But note, though, that the requester can only choose one of the two types of proceedings. Therefore, if they bring a claim, a mandamus lawsuit in the Supreme Court of Ohio and lose, you can feel good to know that they cannot then refile in the Ohio Court of Claims to try to succeed there. So we're going to talk about both of these two today, but let's go ahead and start first with the mandamus lawsuit. Now, this type of action can be filed in pretty much any of the traditional levels of our court system, including a court of common pleas where the public office is located, the Court of Appeals, or directly even in the Supreme Court of Ohio. And frankly, this is where we see probably most of our litigation is in the Supreme Court of Ohio. Now, in mandamus, the requester is asking the court to order the public office to comply with the request or for an order finding that the office violated a procedural requirement of the Public Records Act. If the court finds that there was an unreasonable delay between the time of the request and the production of the records, or if the records were not provided at all, then the requester may be eligible for statutory damages. That being said, there are specific requirements before those can be ordered. Now, you remember how I talked about earlier how a requester can make a public records request either verbally or in writing, and that they have a choice? Well, to be eligible for statutory damages in a mandamus action, the requester must deliver the initial request by certified mail, hand delivery, or electronically, such as an email. And public offices don't try to get cute, trying to say that an attachment to an email is not an email. The courts have looked at that exact situation and found that attachments to emails are still sufficient under the statute. Now, how are statutory damages calculated? Well, they are $100 per day for each business day, starting with the filing of the mandamus action up to a cap of $1,000 for each mandamus lawsuit. Another thing that a court has the discretion to order is that the public office be required to pay the requester's reasonable attorney's fees for those parts of the lawsuit that the requester won. Now, a court may award reasonable attorney's fees if either the court orders the office to comply with the Public Records Act, the office failed to respond affirmatively or negatively to the public records request in accordance with the time allowed, third, the office promised to permit inspection or deliver copies within a specified period but failed to fulfill that promise, or four, the office acted in bad faith when it produced the requested records after the requester sued but before the court issued any order. Now, in this last scenario, the requester is also going to be entitled to its court's costs, but the requester may not conduct discovery on the issue of bad faith, and the court may not presume bad faith by the public office. So that pretty much covers the mandamus action. Well, the second type of lawsuit is what's referred to as the Court of Claims statutory procedure, where there is a special process for public records cases. Now, the goals of the public records process in the Court of Claims are to make filing a lawsuit against a public office easier, faster, more efficient, and less expensive. To this end, the process starts with a simple standard complaint form that's only one page and costs only $25 to file. Further, the requester is only required to attach the underlying public records request and then any follow-up communications it had with the public office. In almost entirely all of cases that are brought for the Court of Claims, the case will automatically go to mediation. A mediator, a mediator will be assigned and will try to help the parties work through the dispute to avoid proceeding further into litigation. Now, if mediation resolves the issue, great, but sometimes it's not successful. And in those instances, the parties proceed to briefing before a special master that is appointed by the Court of Claims. Now, the response deadlines for briefing is going to be very short and no discovery is allowed. Just to give you kind of an idea, we were just involved recently in a Court of Claims case, and it was pretty much about once mediation was terminated, about a week or two, and then another week or two, and then the court issued its decision. Again, the idea here is to have these types of cases resolved in the matter of only a couple of months versus maybe up to a year or more in your traditional mandamus type of action. Now, one thing that's different is that there's no discovery that's allowed in a court of claims case. Once the matter has been fully briefed, the special master is supposed to rule very quickly, and either party may object to the special master's ruling. And if that is even unsuccessful, they can appeal to the Court of Appeals. Now, unlike mandamus cases, a requester cannot get damages or attorney's fees even if they win in the Court of Claims. So, as you can see, litigating a public records violation can cost a public office money in the form of statutory damages, as well as attorney's fees and court costs. But there's also other effects that aren't just necessarily monetary, in that it takes up a lot of time and employee resources. But you can help your office avoid litigation and make litigation easier when it happens by following some best practices that we'll talk about now. The first is that you have a system to document the public records requests you get. For example, we call this a public records log, and it's just one way to do it, and it's going to be very beneficial. One reason for doing this is because all public offices are audited for their compliance with the Public Records Act. Documenting your requests will be incredibly useful in an audit. Also, if you get sued over the request, a log can be important evidence of all the steps your office took in responding. A request log can help an office explain why and when it responded the way it did. A request log can also be useful responding to duplicate requests. Your office might get several requests for the same records, so a request log allows you to track what records were withheld and redacted and make sure your office responds consistently to duplicate requests. So, what are some important things to include in the log? Well, first, you're going to want to document the request itself. So, if the request was in writing, go ahead and just copy the full text of the request. But if the request is verbal, make sure you write it down word for word. Also include some basic information about the request. The date it came in, how it came in, and the name of the requester if you know, and the requester's contact information. Go ahead and document if or how your office acknowledged receipt of the request. Document any and all other communications you have with the requester, and then keep track of all steps that are taken in response. Finally, document what records were provided in response, when they were provided, and how they were provided. If a requester sues a public office for not responding to a request, but the office claims that it did respond, again, the burden is on the public office to prove that it did respond. This means that if a public office sent records to a requester, but the requester claims he never received them, the public office has to show that it actually sent the records. And by keeping a request log that would document those steps would be extremely helpful in this type of situation. So here are some other steps that you can take to avoid public records litigation and to make litigation easier if it happens. First, do exactly what you're doing today, which is attend public records training. Share the information you learn with coworkers and encourage them to take a training. Next, keep lists of common public records issues that your office regularly sees. We had already talked about that keeping a list or a cheat sheet of some common exemptions. And the employee records list in the Sunshine Laws Manual is a great place to start. Also, have a process for receiving public records requests and responding to them. And make sure that your offices are not only aware of the process, but that they actually follow it. Finally, know that there are resources out there to help you. For example, our office publishes the Sunshine Laws Manual, which you might hear me refer to as the Yellow Book, and has many other resources that can help you with these issues. But we'll talk about that in more detail at the very end of today's training. Another way that you can help avoid litigation is to stay up to date on changes to the Public Records Act. Like I said earlier, the Ohio General Assembly frequently not only adds, but also modifies or removes statutes that affect public records. The General Assembly also regularly changes and updates the law governing records litigation. General Assembly sometimes will add exemptions to the Public Records Act, maybe modify existing exemptions, or even eliminating them altogether. And this might be in response to current events or changes in technology. For example, a few years ago, the General Assembly amended the Public Records Act to address when footage from law enforcement body cameras is a public record. And you can keep up with these changes by consulting the Sunshine Laws Manual, which is edited and updated annually to keep up with the law. We also occasionally post updates to the office's Sunshine Laws webpage. The Public Records Act requires that every public office adopt a public records policy. Now, the Attorney General's office is required to provide a model public records policy that other offices can follow. And this model policy is a great place to start if an office is writing its own policy for the first time. You can find the model policy online at the Sunshine Laws page of the Attorney General's office's website through the link at the bottom of this slide. So what do you need to include? What should you include? And what should you not include in public records policies? Well, there are several do's and don'ts on what a public records policy should have. For example, a public office is not allowed to limit the number of public records made available to a single person, limit the number of records the public office will make available during a fixed period, or set a fixed period before it will respond to a request unless that period is less than 8 hours. And the reason for this, again, is that if you find yourself in litigation and you're subject to a failure to meet your own self-imposed deadline, well, then you could be subject to attorney's fees. So those are some things that you should not do and cannot do. Well, what are the public offices required to do? Well, they're required to distribute its policy to the office's records custodian and require that employee to acknowledge receipt. They also need to include the public records policy in any existing policies and procedures manual and have a poster that describes the policy and post it conspicuously somewhere in the office. So let's switch gears and talk about records management now. So the Public Records Act requires all public offices to organize and maintain public records so they can be made available for inspection or copying. This obligation is best accomplished through a good records management system. Records management is what we refer to as the process of establishing and implementing policies and procedures to organize and maintain records across their life cycle. A good records management system is important because of the legal obligation to organize and maintain public records, but it will also save your office time and help keep you out of litigation. So let's look at some of the components of what makes a good records management system. A good records management system is important because offices generate more records than they have ever done before. We talked a lot about how emails, instant messages, and text messages can be public records. Well, every time you send one of those messages, you're creating a new public record that has to be managed and maintained. And the more records you have means the more records you have to pay to store, produce for public records requests, and produced in other litigation. A good records management system will correctly identify records as eligible for disposal and will document all disposal activities. Following a good records management system means that both the retention and disposal of records are transparent, predictable, and consistent. By disposing of records according to a well-run records management program, your office can find current or active records more easily because your system is not going to be clogged with outdated and useless records. Finally, having a good records management system will ensure that your office is compliant with public records law as well as other regulatory requirements. A records retention schedule is the backbone of a good records management system. Now, what do we mean by a records retention schedule? Well, basically, it's what describes different groups of records and says how long those records need to be kept. Essentially, they are mini policies that tell a public office how long they need to keep certain types of records. So what are some things that a retention schedule should include? Well, it should have a title. It should describe the function of the records it concerns and identify what types of information is contained in the record series. It should list the retention period, which is the length of time the public office must keep the record. It should state what format the record is kept in. And then finally, it should describe how the public office will destroy the record. Now, it's important to note that unless a law says otherwise, your office can decide how long the records in each record series will be kept. And this is what we call the retention period. And this is an important part of records retention schedules. Now, in setting the retention period, an office should consider a few factors, including the administrative purpose of the record over time, whether the record will be subject to any fiscal tracking, such as a local or a state audit, the legal value of the record over time to both not only the office, but also the public generally, and then finally, any potential historical value. Now, the Ohio History Connection may decide that a particular record series has some sort of historical value beyond the purpose or goals of what the office had in mind, and therefore may ask that either the originals or copies be sent to the History Connection at some future date. Now, as a practical matter, a good retention period is going to strike a balance between maintaining the record for as long as it may be useful, but not making the office look like an episode of the old show Hoarders, if you remember that, adding unnecessary years to the retention period. All right, so let's say that we have your records retention schedule done for a particular type of record. That's great. You've set the retention period, you've considered all the relevant factors, and you're wondering what to do next. For example, can you start disposing of these records that have met their retention period? Well, not so fast, my friend, as Lee Corso would say. First, your retention schedule has to be approved. And once the process is complete, only then can a public office have the authority to maintain and dispose of the records covered by its description. Not surprisingly, there's a specific process to go about approving retention schedules. The first step is approval by the local records commission. Membership in local records commissions is set according to a statute for each level of government. If the commission approves and signs off, the local records commission will then send the schedule to the Ohio History Connection, which has 60 days to review and sign. The retention schedule then finally goes to its last stop, which is the Auditor of State, who similarly has 60 days to review the schedule and give the final sign-off. The Public Records Act specifically requires public offices to have their approved retention schedules readily available to the public. This is yet another reason why a public office should have clear and up-to-date retention schedules for all the public records in its office. Posting your retention schedules online and maintaining a physical copy in the office is what's considered best practice. One key point that I want to note about here is that an office can only get rid of records that are according to an approved records retention schedule. So this means that if you have records that do not fall under an active retention schedule, then the default retention period is indefinitely. You must either have a law directing your retention and disposal of records or an approved records retention schedule covering every record in the office, and you cannot dispose of records until you do. But that said, having the retention schedule is not enough. You actually have to keep up with the schedule and destroy records once the retention period is met. This is going to save time and reduce storage and processing costs. Remember, if you fail to dispose of records that have met their retention period, then those records are still kept by your office and are still subject to request under the Public Records Act. This means that if you have a file on your hard drive that could have been destroyed years ago and a public records request is made for that file, the file might have to be produced. Prompt and proper disposal of records thus reduces the potential burden on your office. Now, we've talked a lot about how electronic records such as emails and texts can be public records if it documents the activities of the office. And these can still be public records again, even if they originate from or even stored on personal accounts or devices. Well, managing these records can be tricky, so it's important to keep a few things in mind. First, retain records based on the content of the record, not the format, author, or storage location. This means that an office shouldn't necessarily store all emails together or all text messages together. Instead, store them according to the content or subject matter. So when it comes to the retention of emails and texts, first determine the applicable records retention schedule. For example, general correspondence or a particular type of case or matter. The records will need to be retained or preserved based on the applicable records retention schedule. Retaining and preserving certain electronic records might also require moving, copying, or taking screenshots to preserve the record. For example, let's look at the text that we saw earlier in the training. We know that at least some of the content of this message documents the activities of the office. This message will thus need to be retained and preserved according to the applicable records retention schedule. And this could include requiring the employee to take a screenshot of the message and then send it to their work email account to properly store. You might need to do the same thing for emails sent from a personal email address. And if you store records that document the activities office on a personal computer, hard drive, or any other non-government account, such like Dropbox or Google Drive, those records will also need to be moved to the office system to retain and preserve. Keep in mind that if there's a request for records that you've stored on a personal account or device, but the records were never transferred to be retained on the office system, it is possible that your personal account or device will have to be searched. That is not something that anyone wants. So, what do we suggest? Well, it's a best practice to just simply avoid using your personal accounts and devices altogether. Now, we understand that we use our phones for just about everything in today's world, and it can sometimes be difficult to avoid using them for work. But it's always best to try to keep work on the office's device and accounts only, where they can be easily stored in accordance with the office's records retention schedule. Finally, as technology and our use of things like social media changes, your office needs to keep up with those changes in your records retention schedules. For example, 10 years ago, your office probably didn't need a records retention schedule to cover something like social media posts, or perhaps office podcasts, like this retention schedule from our office that's included on this slide. But chances are good now that you need one, particularly for something like social media posts that can automatically be deleted after a certain period. You should continually check and update your records retention schedules to make sure that they cover all of your records. You should also include in your public records policy how employees are required to maintain all public records, no matter where those records are kept. Here again is the Attorney General's public records policy for electronic records. Note that it requires employees to retain all emails and other electronic records in accordance with applicable records retention schedules, no matter where the record originated. Now, transient records are a type of record that every office and every employee receives and drafts. A transient record is one that is useful only for a short period of time and thus loses any administrative value fairly quickly. For example, a draft copy of something might be considered transient. For example, a draft copy of a press release would lose its administrative value once the final version is issued. A message discussing meeting times might be transient because once that meeting has been scheduled or once it has happened, the message is no longer useful. All of those thankful thank you emails that you send to your colleagues, accepting or declining calendar invites, and read receipts are all examples of records that have only a very limited period of usefulness. Every public office needs to have a records retention schedule covering transient records. Retention periods for transient records should be short, perhaps providing that they can be destroyed after they no longer have any administrative value. With an appropriate records retention schedule in place covering transient documents, the public office can delete these non-substantive documents immediately because they have no ongoing administrative value. But if you do not have an applicable records retention schedule, then you must keep all of these records. Think about just how quickly these kinds of informal communications can pile up and make it hard for you to search for substantive records. But if you have a good records management system and records retention schedule in place, then you'll be able to keep your records to a manageable level. So what would this look like? Well, on the screen here is the Attorney General's records retention schedule that covers transient records. Note that the retention period provides that both electronic and paper transient records are treated the same and can be destroyed when they are no longer of any administrative value. Now, there is one last special type of litigation and liability when the claim is the improper disposal of public records. And that first thing is, again, this is separate from your traditional public records litigation and rather is solely focused on records destruction. The available remedies here are going to include attorney's fees and damages of $1,000 for each violation. Now, since each violation may mean each single document within a larger file of documents, then the forfeiture penalty for improperly destroying even a single folder of records can quickly add up. But that being said, these damages are statutorily capped at $10,000. Second, if improper records destruction prevented your office from providing records in response to a public records request, a requester can sue your office additionally in one of the two types of Public Records Act cases that we discussed earlier. So either your civil mandamus action or your court of claims proceeding. So let's end our discussion of the Ohio Public Records Act by talking about some records management resources. There are several resources that are out there that can help public offices with record management issues and to help avoid the types of litigation that we've discussed today. The State Archives through the Ohio History Connection is one such resource and has a website that is excellent when it comes to local government records retention and other records management issues. The second is the Department of Administrative Services website, which has examples of schedules approved for state agencies. You can search the website by agency name or record category to see some of these examples. The Ohio Electronic Records Committee is another useful resource on the issue of electronic records management. Now, while we cannot endorse or certify their opinions, their website has papers on electronics management and email records that can be useful to you. Finally, the Ohio County Archivists and Records Managers Association is an organization for county record managers and has a discussion forum for records managers to share information about their records programs. All right, that brings us to the end of our discussion of the Ohio Public Records Act. I have 3:36. Let's use the remaining 5 minutes of our break now, and we'll come back at 3:41 p.m. and we'll end today's training by talking about the Open Meetings Act. So I'll see everybody in 5 minutes. All righty, it is 3:41 by my watch. So let's go ahead and spend the last 34 minutes of our time together talking about the Ohio Open Meetings Act. Now, the Ohio's Open Meeting Act is going to cover the meetings of public bodies. And we're going to look at these important terms and definitions under the Act. And then we're also going to discuss what are the obligations of public bodies that are subject to the Open Meetings Act. We'll look at when a public body is allowed to convene an executive session, which is an exception to the openness requirement under the Open Meetings Act. And then finally, we'll look at the consequences of not complying with the Open Meetings Act, including the types of litigation and legal remedies that could be available to someone who is aggrieved. So it's important to note that the Open Meetings Act applies to the meetings of public bodies. Now, as you'll be able to tell by kind of the quotes on this, meetings and public bodies are going to have very specific definitions under the law. And this is because there are certain requirements that public bodies must do when they conduct their meetings. But we'll talk about those here right now. So first, what is a public body? Well, public bodies are generally decision-making bodies found at any level of government. And the definition is going to include all decision-making bodies of the state, its political subdivisions, and school districts that are created by law, including their subcommittees and their committees and subcommittees. Now, sometimes it may not be clear if a group or an entity is a public body that falls under the Open Meetings Act. When deciding this issue, courts have used the following factors to determine whether a group is considered a public body. The first is the way the entity was created. Second, the name or official title of the entity. 3, the members of the entity. 4, whether the entity makes decisions. And 5, who does the entity advise or to whom does it report? Now, applying these factors in one case, an appellate court found that an urban design review board was a public body because it made decisions and gave advice to the city council about certain land development issues. In a separate case, an entity was a nonprofit corporation that was not governed or controlled by a public body. In that case, the court found that the entity was not a public body for purposes of the Open Meetings Act. Now, if you are with an entity and you're not sure if whether or not you're a public body subject to the Open Meetings Act, make sure you seek the advice of legal counsel. All right, the next important definition under the Open Meetings Act is what do we mean by meeting? Well, when you have the following 3 elements on this slide and they're all met, that is when you have a meeting. So first, it has to be prearranged. Second, it has to involve a discussion of the public business of that public body. And then third, by a majority of its members. Again, only when you have all 3 present does a public body have to comply with the obligations of the Open Meetings Act. So let's look at all 3 of these parts of the definition. The first part is that it must be prearranged. Now, it's usually clear when a meeting is prearranged because members of the public body collectively agree to meet at a certain time and date to discuss official business. But sometimes it's not going to be so clear. For example, what about a discussion that starts with an email from one member of the public body to another member and grows into a discussion through an email chain? Is a meeting prearranged if not all the members are participating at the same time? In other words, if there's a series of back-to-back meetings, each with less than a majority of the public body, but the same topics are discussed. Well, luckily for us, the Supreme Court of Ohio has said that both serial-style meetings and meetings that happen solely over emails can be considered prearranged for purposes of having a meeting under the Open Meetings Act. This means that a meeting can be considered prearranged even if it's not face-to-face and even if not all the members are participating at the same time. That being said, the Open Meetings Act does not prohibit unplanned encounters between members of public bodies, such as hallway discussions or the good old casual water cooler talk. Let's turn our attention to the second part of a meeting, and that is it must include the discussion or deliberation of official business. Now, deliberation involves the weighing and examination of reasons for or against a course of action. Now, some courts have found that certain types of activities do not constitute either discussion or deliberation. By way of example, a gathering of the members of a public body is not a meeting when the members are only collecting information, attending presentations, or having isolated conversations. Now, we already kind of talked about this, but I want to talk about it a little bit more, and that's that the Ohio Supreme Court has found that serial meetings can violate the Open Meetings Act. Again, by serial meetings, I mean separate meetings that are attended by less than a majority of the public body's members, but when you take them together in the aggregate, a majority of the members have discussed and deliberated on the same topic. Now, in a case where this happened, there was a city manager who held a series of private back-to-back meetings with the members of city council to discuss building a sports stadium. For some reason, I don't know what it is with open, always seems to follow sports stadium. Now, less than a majority of council members attended the individual meetings, but when taken in the aggregate, a majority of members attended each series of meetings. The court referred to this as a game of legislative musical chairs that violated the clear intent of the Open Meetings Act. Again, the Supreme Court of Ohio applied this same idea to conclude that a meeting can occur when a majority of members of a public body discuss public business in a series of emails. There, the court said that the Open Meetings Act prohibits any private prearranged discussion of public business by a majority of members of a public body, whether that discussion occurs telephonically, by video conference, text, tweet, email, or any other form of communication. A very strong decision from the Supreme Court. Now, it's important to know that you can have a meeting for purposes of complying with the Open Meetings Act, even if you don't call it a meeting. I'm sure all of us have attended either a work session, a retreat, a happy hour. You can call your gathering whatever you want, but just know that if public business is discussed among a majority of the members of a public body, then you have a meeting that requires that the Open Meetings Act be complied with. The important point here is whether all three parts of the definition are present, not what lovely word you've given your gathering. So, you have all three parts of the definition of a meeting. What do you have to do if you're a public body in order to comply? Well, the Open Meetings Act provides three obligations that a public body must do when conducting their meetings. The first is that they must provide appropriate notice of meetings to the public. Second, public bodies must take action and deliberate on public business in open session. And third, public bodies must take and file meeting minutes. So let's start first with notice. So every public body must establish a reasonable method for notifying the public in advance of its meetings. In general, most public bodies can make their own rules for giving notice of their meetings. The only requirements are that the notice is consistent and designed to reasonably reach the public and the population that the public body serves. Now, the type of notice that you're required to provide is going to depend on the type of meeting that you're intending to conduct. To this end, there are two different types of meetings, a regular meeting and a special meeting. Now, regular meetings are held at pre-scheduled intervals, for example, the first Thursday of every month. Notice for regular meetings needs to include the time and place of the meeting, but you do not necessarily need to include the agenda or topics to be discussed. Special meetings are going to be all meetings other than a regular meeting, and and that would include then regular meetings that are rescheduled for a different date or time. Now, notice of special meetings must include the time, place, and purpose of the meeting. Note that this additional purpose requirement for notice of special meetings that is not required for regular meetings. Also, a public body must give at least 24 hours notice of special meetings to media who have requested to be notified. Now, although I said generally speaking there are only two types of meetings, I do want to talk about a special subset of special meetings, and those are referred to as emergency meetings. Now, a public body can hold an emergency meeting to discuss an issue that requires immediate action. Now, the same rules regarding notice are going to apply to emergency meetings, except that, as they do for special meetings, except for emergency meetings, a public body must give immediate notice to media who have requested such. The second obligation that a public body has under the Open Meetings Act is to ensure that meetings are always open, with some very limited exceptions that I'll talk about here in a minute. Importantly, the openness requirement means that public bodies must vote on and take all official action in open meetings. The openness element also imposes requirements as to the forum where an open meeting is held. This means that the space in which a public body meets must be open to the public. A meeting is not open to the public, for example, if there are locked doors or barriers to entry. But the public body must also have its meetings in the geographic proximity of the area that the public body serves. In other words, a public body in Cleveland cannot have its meetings in Cincinnati. Finally, the venue must be large enough to fit the anticipated audience. So if you expect 500 people to show up, you probably can't have the meeting in a small conference room. Rather, you're probably going to have to find an auditorium, a gym, or something else that's big enough to accommodate that many people. Again, the whole point of open meetings is to allow the public to observe the workings of a public body and to understand the reasoning behind the public body's decision-making. So let's discuss some common ways that public bodies' voting or decision-making processes could violate this openness requirement. So a public body can never vote by secret ballot. And one public body recently violated the Open Meetings Act when it voted by secret ballot, even though it retained the ballots as public records. The public body's deliberations must also be open to the public. A public body, therefore, cannot whisper discussions of public business so that the public can't hear what is discussed. The Supreme Court of Ohio has found that the Open Meetings Act prohibits any private, prearranged discussion of public business by a majority of the members of a public body by electronic means as well, such as email, text, or tweet. Now let's talk about something that comes up a lot, which are consent agendas, which are a more complicated topic. Now, a consent agenda is something that groups together the procedural, self-explanatory, and non-controversial items that are typically included in a public body meeting agenda. The public body then goes ahead and votes on the entire agenda in a single motion with a single vote. The Supreme Court of Ohio has said that using a consent agenda is not prohibited by the Open Meetings Act, but that a public body cannot use one to constructively close a public meeting or as a way around the act. Nor can a public body vote on a consent agenda when the public has no way of knowing all of the items on the consent agenda. So therefore, a consent agenda should never include items that require deliberation, decision-making, or action, and the public needs to have a way of knowing what is included in the consent agenda. Now, you'd be shocked to learn in today's world that the Open Meetings Act does not contemplate that members of a public body can participate virtually through things such as FaceTime, Skype, Zoom, Teams, or even by telephone conference. Thus, in order to be considered present for the purposes of not only establish a quorum, but also voting, a member must be physically present unless specifically authorized by law. Now, there are a small number of public bodies that have statutory authority to conduct meetings via telephone conference or some other remote means. But in the absence of any such authority, public bodies may not conduct their meetings via electronic or telephonic conferencing, and the members are not considered present if they are not physically present. Now, if you have any doubt about whether or not the law authorizes your public body to meet in any other way other than in person, make sure you consult your attorney. So, in today's age, a lot of things that are coming up are what happens with recording public meetings and also public speaking during a meeting. Well, talking first about the former, a public body cannot ban audio or video recording of its meetings, but a public body can modify or even limit recording of its meetings if the recording is disruptive. Also, the Open Meetings Act requires only that attendees be able to hear meetings, but not necessarily be heard or participate in the meeting by offering their input. So this means that public bodies do not have to allow the public to speak during its meetings. However, public bodies may want to go ahead and establish their own rules and procedures for when and if they allow members of the public to speak during their meetings. Now, we're going to talk about a big exception to openness here in a minute, but before we do that, I want to finish by talking about the last obligation under the Open Meetings Act, which is to take and keep full and accurate meeting minutes. Minutes must be prepared promptly, filed, and maintained by the public body. Now, what do you need to do to have them maintained? Well, you don't necessarily need to have minutes be a verbatim transcript of exactly everything that was said and what happened during each meeting. Rather, meetings must just only have enough detail to allow the public to understand and appreciate the rationale behind the public body's decisions. Minutes must also be accurate. The Supreme Court of Ohio recently found that a public body violated the Open Meetings Act when its minutes contained glaring inaccuracies. Specifically, the public body's minutes incorporated documents that didn't actually exist. Something else to keep in mind is that meeting minutes are public records. This includes drafts of minutes as well that are circulated for a public body's approval, and any recordings that are taken for the purpose of later transcribing those into minutes. For example, the person tasked with putting together meeting minutes might go ahead for ease and record the meeting to help them transcribe the minutes later. Well, that recording is a public record for as long as it's kept. Now, we talked earlier about transient records. It's very likely that that recording would be transient once the final minutes have been approved. Now, the Public Records Act requires that the public body provide public access to its meeting minutes upon request. And therefore, all of the requirements of the Public Records Act are going to apply to meeting minutes. So now let's talk about a big exception to the openness requirement, and that's executive session. An executive session is the only time that a public body is allowed to meet privately during a public meeting. Now, there are very specific procedures for going into executive session. An executive session may only be held for one of the reasons listed in the statute that I'll talk about in a second. But first, what is the proper procedure? Well, first, you must have a motion that states the purpose for the executive session, and the motion must be specific as to the matters to be discussed. The reason for the executive session must be exclusively for the purposes of considering one or more of the 9 approved topics. A public body cannot discuss any topic in executive session other than a topic specifically identified in the motion to go into executive session. Once a motion is made, it must be followed by a second, and then a vote to adjourn into executive session must be made by roll call vote by a majority of a quorum of the public body. This roll call vote must then be recorded in the minutes. Another procedural requirement is that a public body can never open or close a meeting in executive session. The meeting must always begin and end in open session to allow the public to know when the meeting and executive session began, the purpose of the executive session, when the executive session ended, and when the public body reconvened into open session. Now, I've mentioned these 9 topics. Well, let's go over them. So there are 9 permissible executive session topics provided in the Open Meetings Act. As we just discussed, when a public body moves to go into executive session, it must put the reason for moving into executive session on the record. Well, that reason can only be to discuss one of these 9 topics. A public body must be careful about what and how they put for the reason for going into executive session on the record. Courts have found that quoting the specific language of the Open Meetings Act is sufficient to go into executive session. So, if a public body is going into executive session to talk about personnel matters, it might say that it will discuss the appointment, employment, dismissal, discipline, promotion, demotion, or compensation of a public employee in executive session, which essentially mirrors the language of the Open Meetings Act. Again, this is likely sufficient even if the public body does not end up discussing each of these subtopics during the executive session. A public body does not have to discuss every topic included in an executive session motion. For example, the public body might discuss employment, dismissal, discipline, demotion, and compensation, but not appointment or promotion. Now, one word of caution. A public body should never go overbroad in identifying the executive session topic. In one example, a public body read the entire text of the Open Meetings Act on executive sessions verbatim, therefore including all 9 topics. On review, the court said that the public body violated the Open Meetings Act because it needed to state the specific purpose of the executive session, not every possible purpose. So a good rule of thumb here is that the motion should include all the topics that might reasonably be discussed during an executive session. And let's look at a few of some more common executive session topics. So discussion of personnel matters is a very common reason to move into executive session. Note that merely putting personnel matters on the record is not sufficient. Instead, the public body must go on the record and state the specific personnel matter at issue, including either or all the consideration of the appointment, employment, dismissal, discipline, promotion, demotion, or compensation of a public employee or official. Note, though, that an executive session can never be held to consider the discipline or removal of an elected official. Finally, appellate courts disagree on whether discussion of personnel matters must be limited to one person or if it can include a broader discussion of employee matters like the compensation for a group of public employees. Therefore, public bodies should consult their attorneys to determine which appellate line of cases applies to them. Now, another common reason to go into executive session is to discuss pending or imminently pending court action. Now, threatened litigation is considered imminent and may be discussed in an executive session. But a public body cannot use the pending or imminent court action reason to go into executive session merely to discuss any old legal matters with an attorney. Similarly, note that just because an attorney might be present in executive session does not mean that this reason applies, nor does it mean that everything discussed there is privileged or confidential. And just because a member of the public body happens to be an attorney does not mean that they are acting as the public body's legal counsel. So that kind of covers a couple of the topics that you generally will see. So now let's talk about a couple other broader things about executive session. First, who can be present in an executive session? Well, obviously, members of the public body can be there, but if you have a makeup where there's a majority and minority, the majority can never exclude the minority. Additionally, the public body can invite anyone else who they would like to be there with them in an executive session. So just because a public body has properly gone into executive session does not mean that they can do whatever they want there. Rather, there's still restrictions. First, a public body can never vote or make any decisions in executive session. Also, a public body cannot discuss matters other than the reason for moving into executive session that was put on the record. This is true even if the topics are related. For example, if a public body moves into executive session to discuss firing an employee and the topic of pending or imminent court action related to the firing comes up, the public body cannot discuss that topic. Instead, the public body must go back into open session and properly move into executive session to discuss the topic of pending or imminent court action. Again, like I talked about earlier, to the extent you can kind of, figure out what is likely to come up in executive session, put that in your motion. So it's important to know that nothing in the Open Meetings Act provides for any sort of confidentiality of discussions that occur in executive session. Other sources of confidentiality requirements might apply, though. For example, ethics laws or confidentiality related to certain education and student matters. But just know that there is no automatic cloak of confidentiality that applies to all executive session discussion. Also, just because a public body discusses a document in executive session does not mean that the document necessarily becomes confidential. A public body may be required to release documents discussed solely in executive session under the Public Records Act. While a document might fall under other public record exemptions, there is no public records exemption for documents discussed during executive session. Now, public officials must follow certain ethics rules. One of those rules prohibits public officials from disclosing confidential information that the official acquired in the course of their official duties. The Ohio Ethics Commission has concluded that those ethics rules may prevent a public official from disclosing information discussed during executive session. As we just talked about, the use of executive session by itself does not create a duty of confidentiality, and there's no automatic cloak of confidentiality that applies to executive sessions. However, if a public body properly moves into executive session and the information discussed is confidential under a statute or has been clearly designated as confidential, then the public official may have a duty to keep that information confidential under Ohio's ethics laws. So now let's talk about when things go wrong. Well, the Open Meetings Act is what's commonly referred to as a self-help statute. This means that anyone who believes a public body has violated the act can sue the public body to comply. This also means that there's no public entity that has the authority to enforce the Open Meetings Act, including the Attorney General. Excuse me. If a person believes that a public body violated the Open Meetings Act, then they can sue and ask the court to issue an injunction that requires the public body to comply with the law. The action must be filed in the Court of Common Pleas where the meeting at issue took place within 2 years of the alleged violation. Now, unlike the Public Records Act, Open Meetings Act lawsuits cannot be brought in the Ohio Court of Claims. The person bringing the lawsuit is the one that has the burden of showing that the public body violated the law. This is going to be true even if that person claims that the public body went into executive session improperly. Note that this is different from the Public Records Act, where the public office has the burden of showing that exemption applies. If the court finds that the public body violated the Open Meetings Act, then the court shall order the public body to also pay a fine of $500 to the filing party for each violation found. The court must also award all court costs and reasonable attorney's fees. However, attorney's fees may be reduced or even not awarded at all if the court finds two things. First, that a well-informed public body would reasonably believe that it wasn't violating the Open Meetings Act, and that a well-informed public body would reasonably believe that its conduct served the public policy underlying the authority asserted for the conduct. Another potential liability is invalidating an action. For example, if a public body adopts a formal action after deliberating the issue in an improper executive session, then the formal action may be invalid and the public body must start over to adopt that action. A formal action taken in a meeting for which notice was not properly given may also be found to be invalid. Finally, a member of the public body may be removed from office by a prosecuting attorney or the attorney general if they knowingly violate an injunction issued against them for past violations of the Open Meetings Act. So that pretty much covers the Open Meetings Act. So that brings us to the end of today's training, where I just want to briefly go over some resources that are available if you have questions about Ohio's sunshine laws, or if you want to learn more about what we've covered today. First, the Attorney General's Sunshine Laws Manual, again, something that we typically call the Yellow Book, is an excellent resource. The manual is updated yearly to include the most recent statutory and case law changes. The link on the slide is to the online version, which can be downloaded, has hyperlinks to cited cases, and is also searchable, which is very helpful. That being said, if you're old-fashioned and you want your own hard copy, we also still print hard copies of the Yellow Book. So if you want a hard copy, go ahead and contact our office and we'll mail one to you. Don't worry, I'm about to put our contact information up on the slides. Training is another great way to learn more about Ohio's sunshine laws. The Attorney General's office provides several training opportunities. As some of you know, all elected officials or designees must attend a 3-hour sunshine laws training during each term of office, which is why today's training is 3 hours long. The Attorney General's office offers 3 ways in which to fulfill this requirement: online videos, a live webcast, but also in person. Now you can watch the videos at any time and at your own pace. The live trainings are offered about every 6 weeks, and in-person training is offered a few times a year in different areas of the state. To see the current training schedule or to register for training, go to the Attorney General's website, which will be on this next slide. All training courses are always free and open to anyone. Our office's Sunshine Laws website also has a lot of helpful resources. This page has links to the current Sunshine Laws Manual, several useful appendices, a list of all confidentiality provisions in the Ohio Revised Code, and the Attorney General's opinion on the Public Records Act and the Open Meetings Act. You'll also find the model public records policy we discussed earlier. The page also has links to short training videos on specific Sunshine Laws topics, as well as all information you need to register for a training. Finally, our office is always available to you as a resource. You can email this address or call the number on the slide to reach the Public Records Unit, of which Heather and I are members. Although we can't give you legal advice, we can do our best to point you in the direction of an answer. As a final reminder, we no longer issue paper attendance certificates. If you need proof of attendance, an attendance report will be available on the Attorney General's website and can be downloaded about 72 hours after the training. All you need to do is go on the website on this slide and click the link where you see the arrows. For attorneys who want CLE credit for attending today, CLE credits or hours will be submitted to the Ohio Supreme Court after the attendance report has been processed. On behalf of myself and Heather and everyone here at the Ohio Attorney General's office, I would like to thank you again so much for today's training. Your day. Take care.